Um, I've just had an audio message that the recording is in progress, so that's a good prompt to remind you all that the session will be being recorded, including questions and so on, and to say thank you for joining us. I'm really looking forward to chairing this session. I'm going to turn my camera off and mute myself shortly, and I please ask all of you to do the same, unless you are the speaker, unless and until you are requested to turn your camera and your mic back on. The format of today is going to be 4 presentations back to back, followed by around 15 minutes for questions and discussion. As you'll know, the focus of the whole conference is vulnerability and how this concept's defined and understood in different contexts. So if you could please bear that in mind when you're thinking about your questions, that'd be fantastic. When it comes to the Q&A, I'll remind you of this, but you can either use your raise hand function, so that's under the reactions tab at the bottom of your screen, or you can type in a question into the chat box. Okay, in that case, I will just begin by introducing our first speaker, who is Professor Steve Headley, Professor of Law at the University of College Cork, whose presentation is titled, Does Tort Respond to Vulnerability? Should it? So I'll hand over to you, Steve. Thank you.
Thanks very much. I'll try and share the screen now. We tested this before. Can everybody see that? Yeah, good. Yep. Right. I'm going to be talking about the law of tort then, of compensation for wrongdoing, if you prefer. That's often been seen in the past as unpromising territory for vulnerability theory. Looking at the papers we've had so far in legal terms, there's been an awful lot of contract law, not so much tort law. And that's pretty representative of the scholarship in this area. What I'm going to do in my 15 minutes is very programmatic. It's up there. I want to ask first the easy question: can you see tort in terms of vulnerability? That's relatively straightforward, yes, and I'll explain it. The difficult one is the second one. Should you see tort that way? And the fact that most tort lawyers answer no, you shouldn't, is why I think there's so little written on this. If at the end of that I convinced you that actually it is preferable to see tort through a vulnerability lens, then we can go on to the next question. If we are going to see tort in terms of vulnerability, what's the next step there? How should we develop the law of tort? So the first stage, can you see tort in terms of vulnerability? Well, it's easy enough to do. If you look at the typical tort case from the point of view of the person bringing the claim, they'll typically be the victim of some accident which they never saw coming, which is why the accident happened. An awful lot of cases involving transport accidents, quite a lot of cases involving work accidents, and all sorts of oddities. Every law student gets exposed to a weird case about injuries caused by somebody enjoying a soft drink in a cafe in Scotland in the 20s, and that all went horribly wrong for reasons I won't bother recounting here. In all of these cases, the victim's vulnerability is cruelly revealed by the way things worked out. The law makes a money award against the person who supposedly whose carelessness led to this catastrophe. So you can certainly, it's easy enough to see tort as concerned with the vulnerability of the person now making the claim, affording them a sort of insurance against bad behavior by others. Why then don't lawyers see it that way? Well, the difficulty is that the reason why they don't is because they also look at tort from the other side there. They look on tort as a matter of rights. There's a famous saying that I have the right to swing my arms, but that right terminates at the point that my arms get anywhere close to your nose. Tort is seen as line drawing between individuals there, as setting out the various different rights that people have. If you look at it that way, of course, then that's exactly the opposite of what's usually understood as defining vulnerability. Rather, it's about seeing law in classic liberal terms, setting limits to what people can do, what they're not allowed to do. Tort from that point of view is a list of don'ts. Don't injure the people around you. Don't even touch them unless they say so. Don't damage their property either. And that list of don'ts, of course, doesn't include the more caring don'ts. There's no torts. Don't look away when people need your help. Don't say that the problems of others are not your concern. That's exactly what tort law doesn't provide for. So you can see tort either way. You can see it in terms of safeguarding people against vulnerability, but equally you can see it in terms of liberal line drawing, saying what the defendant's allowed to do, what the defendant's not allowed to do, which is obviously a very different sort of a question. Can we choose between those different perspectives? I very strongly argue for the vulnerability perspective. And the reason why I do so is that you need to take the step outside the tort textbooks. If you focus purely on tort as in the law textbooks, you can make a very strong case for it being about personal responsibility. The moment you look outside it, you run into the brute fact that these individuals supposedly being held responsible are hardly ever sued. And when individuals are sued, it's almost invariably just a procedural step along the way to making an insurer meet the claim. So while the language in which tort is argued is all about personal responsibility, the person who caused the harm is almost never actually held liable. If the claim is being made, it will be made because there is an insurer down the line who will pay for it. This, to me, very much weakens the case for saying that tort is about personal responsibility. It makes it far more convincing to say that tort is about providing an insurance against vulnerability. It manifestly is based on insurance. Is tort really about personal responsibility? Well, the whole point of liability insurance from the potential defendant's point of view is to make sure they're not held responsible. The reason why you take out liability insurance is so that if some question of liability comes up down the line, you won't be held responsible for it, or at least not in that way. So if you're focusing on tort responsibility as in the tort textbooks, I entirely take the point that it's not really about vulnerability. It's not too surprising that the courts rarely talk about vulnerability. You can see it that way, but it's not a very natural perspective. But when you look at the whole tort system, the way claims are actually brought, actually paid for, the vulnerability perspective becomes more convincing. It makes more sense to regard tort as part of society's provision to strengthen resilience. Tort doesn't in practice regulate how people behave. When people go start looking for evidence that tort law actually regulates the way people behave, they very rarely find it. I can say this with some assurance because this very question has been looked at by researchers for something like half a century now. You have all sorts of surveys of how much difference does it make when you impose liability. Lawyers often cite particular studies as promoting one cause or another, but when you look to the generality of what the researchers have found, there's not much an effect of tort. It has a limited effect in some contexts. There are some people who are sufficiently attuned to what might happen to their insurance premiums for the thought that they might be held liable to have some sort of an effect. But there aren't actually very many of these contexts when you look to general surveys. And sometimes the tort liability actually has an adverse effect. The most famous example, of course, is defensive medicine, where the thought that somebody might be held liable actually makes the medical treatment they're rendering worse. They're so worried about preventing themselves being held liable. Actually, they deliver worse treatment than they would otherwise deliver. And there are other examples as well. Local authorities, for example, who have to pay for repairs to their premises and their insurance premiums out of the same budget. What tends to happen there is that if there are a lot of claims, then their insurance premiums go up. And so there's less money available for repairs to make the premises safer. So that's one case where the effect of liability is actually to make the world a more dangerous place. So the research is a pretty mixed bag, but if you look for general surveys of the effect of tort liability, the overall picture is that there isn't really much of a provable effect on conduct. The main thing about tort is that it provides compensation, which is paid for when people pay their insurance premiums. I've included a reference to the chapter in the Cambridge Handbook of Compliance simply because it's a good recent meta-survey. It's a survey of surveys in this area. So if you're thinking of getting into this area, that's a good place to start. Tort has been this way for quite a while. What I'm describing is not a recent phenomenon as well. The modern growth of insurance was really what got tort started. Tort has been around for a very long time, of course, but it only became a big thing when liability insurance became a big thing. And with rise of demands for workplace safety, there's a gradual separation of the parts of the law that try to make people safer from the parts that actually compensate when there are injuries. That famously led William Beveridge, who planned the modern welfare state, to suggest that actually you should get rid of tort liability, certainly in the context of work accidents. It didn't make the workers any safer, he argued, because of liability insurance. And if you're talking about providing pensions and compensation for injured workers, well, that was what the social security system did, and it did it a lot more efficiently than tort did. So this idea that actually tort isn't doing anything very useful in this context has been around for a while. Tort lawyers tend to think of the law as judge-made here, but that's a gross oversimplification. Yes, tort law is very much made by judges, but when you look to the availability of tort law, what makes it possible for people to sue, how their actions are financed, whether there's insurance, that is not decided by judges. It is a matter of deliberate state policy when mandatory insurance is available. So the idea that tort is a judge-made system of responsibility is a very small part of the picture. So to wrap up, what can we expect of torts? Can it be made to regulate conduct? Well, yes, but only by prohibiting liability insurance, which would be a step too far for most people, I think. Is it a useful way of promoting resilience? Well, there are all sorts of reasons why, if you consider tort as promoting resilience, it's not a very good system like that. It is a very slow system. It's very expensive. It's clearly economically regressive. Some people argue it is actually harmful. There's quite a lot of essays on litigation neuroses, the need to insist that you have been wronged by the other guy, and this is dreadful, and you want compensation and damages. That really doesn't put you in the right frame of mind to put it all behind you and get better, which is what certainly what more catastrophically injured plaintiffs actually need. So, what should be done to the law of tort? I wouldn't urge that we should get rid of the law of tort entirely. There are some situations where really there's no alternative to tort. Effectively, I would really limit that to deliberate torts and cases where tort is protecting fundamental human rights. In that situation, you have to leave the initiative with the person who is injured. You have to leave the possibility that even if the state doesn't want you to, nonetheless, you can come to court and sue in that situation. The need to leave the initiative with the plaintiff in those cases is vital. But most tort cases are not of that sort. The general run of cases are negligence actions where nobody set out to create this situation. It was simply an accident. The current situation where you try to work out which individual was responsible for that accident doesn't, to my mind, serve a useful purpose, not least because you don't actually then go on to have any consequences for that individual. Even if you're absolutely clear which individual caused it, the law doesn't do anything for that individual. Rather, it asks that individual, do you have an insurance policy? And it is the insurer then who ends up compensating. So in that situation, again, I wouldn't want to abolish the law of tort, but replacements are urgently needed. The law of tort as it stands spends a huge amount of money on an inquiry into fault. But then even when somebody is found to be at fault, there aren't any legal consequences for that person. There has to be a better way of doing it. So we would want to have some sort of replacement here rather than simple abolition of tort. So just within my time, that's what I have to say about tort. Thank you for listening.
Thank you very much. That was really interesting. I found it very interesting. I'm sure we'll have questions on those topics at the end. It's my pleasure now to introduce our second speaker, Professor Mark Wark, who's the Louisiana Outside Council of Health and Ethics Endowed Professor of Law at the University Law Center in Baton Rouge, and also a Senior Fellow with the Native American Law and Policy Institute. Mark's going to be speaking today about resilient property and property crisis. So, Mark, are you okay to just kick off now?
Yes, I am trying to share my screen. Let's see if I get this. Oops. I always do this not quite right. There we go. Okay, now. Okay, can everyone see that? Okay. Okay, great, no problem. Thank you for having me, and I apologize for my tardiness. My children had a doctor's appointment this morning that ran a little bit longer than we anticipated. So this, what I want to talk about is resilient property and property crisis. This stems out of a book that Lorna Fox O'Mahony and I have co-written, and that is currently at the publisher and editing process on resilient property. And the focus of our book is on squatters and looking at the problem of squatters on empty land. And what I want to do today is I want to look at how certain property crises become confounded or compounded in the context of other crises, and how that reveals resiliency gaps. And particularly how it shines a light on the role of property in shaping resilience in individuals, or in furthering resiliency gaps in others. So, for example, if we start and we think about squatting just as sort of the base problem, we might think about how property interacts with that problem. So one of the ways that property interacts with this problem is it oftentimes tends to be a framing device, that when we think about squatting and we think about the way owners and other interests interact with squatting, the issue is often framed in terms of a housing or a homelessness problem, a law and order problem, a social exclusion problem, a property rights problem, a neighborhood blight problem, even an immigration problem, or sometimes not even a problem at all, just a reality of modern life that individuals have to that society has to reconcile. And so when we think about layering this on top of vulnerability theory, and particularly the way property interacts with vulnerability theory, we start from the perspective that vulnerability theory recognizes that all humans and human institutions are inherently vulnerable and have different levels of resilience. But the insight that Lorna and I bring to vulnerability theory and to property is that the state itself as a human institution is inherently vulnerable, and that the state itself is also actively seeking out resilience. And that one of the stores of resilience that the state seeks out is the promotion of the private property system, where the state is able to afford not only different actors within society, different forms of resilience, but itself is able to tap into those forms of resilience through certain institutions, like promotion of the market, or promotion of the property system as a form of economic stability. And so when we think about how property crises emerged, and we've seen, unfortunately, in our lifetimes, lots of different property crises, from the 2008 mortgage crisis. What I'm going to focus on a little bit later is how COVID created certain property crises, the way we thought about those crises. But typically there is a way in which states think about crises, or the way that states respond to crises, that a state crisis is identified, the state then begins to respond, and that response can reveal resilience gaps, how different individuals experience vulnerability in the context of not only the crisis, but in the context of the types of resources that are available for addressing that crisis, and that those resilience gaps then create new crises. Sometimes those are crises of legitimacy towards the state, where individuals may ask, why aren't the institutions working better in this context? Sometimes those crises are merely revealing or accentuating the resiliency gaps that otherwise already existed. And so what we argue and we advocate in Squatters in the State is that because the state is a vulnerable institution and is seeking out its own resiliency, one of the things that states should be constructed around is the ability to preserve equilibrium. That since the goal of the state is towards resilience in ever-changing circumstances, we ask how state responses to squatters will impact the ability to be resilient. And in doing so, we look to the literature on equilibrium to suggest that there are kind of four big pivots, or four things that states do that tend to promote their own resiliency in the context of certain problems. So, for example, resilient social systems tend to be flexible, or they're able to absorb stress or pressure. They tend to recover from challenge or crises. They are adaptable. They can change in response to the stress, and they tend to be innovative or able to change in order to more efficiently or effectively address a challenge or crises. And so if we look at how these four things interact with states, we might identify the different points within a state crisis where these equilibrium moments are capable of being identified, or moments where they emerge. So for example, when the state crisis is identified, that's a moment of flexibility where the state is able to demonstrate, if it has those institutions that are built into that flexibility, to respond in a flexible way. The mechanisms that enable a state to recover from crisis, those things are often pre-built into the state prior to the crisis, so that states are able to effectively deploy the resources necessary to recover. And what we mean by recover is we mean returning to a state of stasis, where the state is not responding to crisis, but is responding to normal order. States respond by adapting. Sometimes in the face of crisis, the states will specifically deploy tools that adapt their institutions in order to specifically afford resilience in the face of these problems. And then fourth, that the state is innovative and responds to address conditions effectively. Again, that's probably a pre-built-in mechanism that allows the state to deploy those innovative mechanisms. So as we think about this in the context of squatters, and we think about how squatters present challenges, besides just the ability of framing those problems, what we might look at this is we might look at how squatters are threats to state stability. So on the one hand, squatters present challenges to social identity. Where I live in Savannah, Georgia, we have a very high homeless population. Our homeless population, or what in the UK is called rough sleepers, we have between 4,000 and 6,000 people in our community that are homeless. And our community is a city of 150,000, a metropolitan area of about 350,000 people, right? So it's a fairly large homeless population given the size of the city. I describe this as, if you are wanting to compare, this is comparable on the scale of population to a Los Angeles homeless population. One of the threats that homeless present to the state is the threat of social identity, right? So within Savannah, we have about 30 homeless camps that mostly, for the most part, with the exception of one large homeless camp under a very prominent bridge, remain hidden from the public. And when you tend to look at how the state manages the homeless population within the context of the city, it tends to do so by isolating those homeless camps away from the public, so away from the public areas, and keeping them invisible. They also present threats to economic interests. So one thought relating to homelessness in squatting and homelessness is the extent to which homeless and squatting challenge property values, or challenge the economic interests that other community holders have. They represent threats to political stability. This is far more attuned in Europe, in a sense, and maybe I should say real quick as I'm saying this, these are not my views on the threats that squatters present, but these are taking seriously for a moment how the state would perceive the threats of squatters. But within Europe, there has certainly been significant literature about the role of the autonomous squatters movement and whether they present threats to political stability. In Spain, for example, the real emergence of squatting in the 1990s was built around political protest, and the perception by the state that squatters were that squatters presented a genuine threat to the stability of the state. And so when we think about how these get framed and how squatters get framed, we oftentimes think about this in the context of the discourse of how we talk about squatters and the problems. Teresa Gowan talks about, in the US, the tendency to talk about the discourse through sin talk, sick talk, or systems talk. That we tend to either think about squatters through a law and order perspective, the sin talk. We tend to think about squatters through the sick talk of there is some form of health deficiency within the individual, or we tend to think about squatters within the context of systems talk, which is the overall system has failed these individuals, and therefore we need to find ways to shore up the different systems that serve those populations. As we layer on the property crisis of COVID, one of the things that we think, and we argue in the last chapter of Squatters in the State, that COVID revealed is the tendency of how framing these problems shaped the way states responded to squatters in the context of property claims. So, for example, in the very early days of COVID, the COVID crisis was framed as a public health problem. And therefore, squatters or homeless sleepers or rough sleepers, they were also framed as a public health problem. To put this in the context of Galwin's language, they were seen not as not in the context of sin talk or sick talk. They were seen in the context of systems talk. And so you saw unprecedented action by states to move people inside, right? So you had England, for example, Everyone In campaign. In the US, you had an unprecedented action of mobilizing resources to bring homeless people into shelter in order to avoid the larger public health challenge, right? So Parcells and others in Australia write about this and write about how states moved in the moment of crisis of the pandemic, began to reframe the way they thought about homeless according to these different types of talk. But later on, as the crisis moves on, the crisis became economic, right? And so now people began talking about the crisis in economic terms. And as they began talking about crisis in economic terms, those concessions or those mobilizations that the state made in relationship to the public health problem, those began to dissipate. And now we began seeing the way that there was more of a threat and trying to shore up the threat to the economic challenges. So am I doing okay on time? How much time do I have left for you?
Just a minute or two there, Mark. Sorry it's a short time you have, but that's it.
That's quite all right. So what I want to do is I may want just with the 1 minute left, show you 3 quick slides. One is to think about how the different squatter response cycles map onto COVID response cycles. Because one of the things that we saw is the way that states responding to these threats created new challenges of resiliency gaps that the state then had to respond to. And we saw these 4 responses just real quick in states in the way they deployed moratoriums on evictions. That was one very particular response, but then that created a new resiliency gap in relationship to the economy that states were thinking about. You saw some states deploying forceful evictions of squatters still as a second layer response to this problem. You saw the provision, as we already talked about, of providing temporary space for rough sleepers. And you also saw some states focusing very particularly on the increased resilience of squatter settlements. I'm happy to talk more in the Q&A session, but I don't want to take up other people's time. So thank you very much.
Thanks, Mark. You managed to pack in a lot there in a short slot, so thanks so much for doing that. And now we're moving on to our third speaker, who is Dr. Sarah Brown from the professor, who's actually, sorry, I don't mean to raise this as an issue, it just was on my notes. Not a professor, but nevertheless a very distinguished guest for us today at the University of Leeds, who's speaking about vulnerability and credit. So over to you, Sarah.
Thanks, Chloe. Well, first of all, thanks to Tim for inviting me to speak at the conference today. I've had an interest in vulnerability and consumer credit for some time, and I was lucky enough to be part of the team that contributed to Christine and Severin's edited collection last year on vulnerability and access to justice. Vulnerable consumers have become a central focus in the provision of credit and the regulation of suppliers of financial services in recent years. And this is where my interest has arisen over these years. And what I'll do is I'll quickly touch on the regulatory framework at the beginning of the presentation, and then I'll go on to discuss the concept of vulnerability. What do we mean by vulnerability in relation to credit and consumer credit? And I particularly want to focus on the relevance of Professor Martha Feynman's work on the vulnerability theory and how this can help form the direction of travel in relation to consumer protection in this particular space. So what I'm going to try and do now is share my slides, which I hope will work, and forgive me if it goes wrong, but we did try in the beforehand and it seemed to work. So can everybody see those now?
All working for me.
Right, great. Okay, thank you. So just to give you everybody a little bit of background first, the UK has one of the most sophisticated and long-standing consumer credit markets in the EU. Just to give you some feel for the macroeconomic importance of this market, in September 2020, there were £1.68 billion owed by individuals in the UK, and the average debt per adult was £31,798. So you can see it has a big macroeconomic impact. But of course, that kind of credit, that kind of debt comes at a social cost. And the FCA's recent Financial Lives survey showed that 5.1 million of credit consumers were constantly or usually overdrawn, and 23.7 million of adults were unable to cover living expenses for 3 months or more, or they could only do so by borrowing to cover those expenses, and often borrowing through high-cost credit. Now, protection for consumers has traditionally been based in a neoliberal tradition and a competitive free market. And the idea is that if you create an environment for rational choice, then this will naturally follow if the conditions are right. But there are clearly some problems with this, as we will come back to in a few minutes. And how is this protection delivered then within this market in relation to consumers? We heard from the FCA earlier on. The FCA, Financial Conduct Authority, are the regulator and supervisor of the consumer credit market, and they also provide authorization for consumer credit suppliers. They provide transparency provisions and rules in relation to pre- and post-contract information. So any creditor must give information to the borrower both before they enter into the contract and during the continuation of the relationship. For instance, if something becomes due, if they're overdue on payments, etc., interest rates, that kind of thing. There are also legislative provisions in statutes such as the Consumer Credit Act, which allows for things like cancellation rights, joint creditor liability, and so on. In terms of more maybe effective protection, there are the responsible lending requirements, which are contained in rules made by the FCA, and these require creditors to consider the creditworthiness of a borrower, whether or not they can afford the debts or affordability of the borrowing, and whether or not the borrower is likely to be able to sustain that payment over a period of time. There are also requirements about fair treatment and fair terms, and the Financial Conduct Authority has a set of high-level principles which suppliers must reflect in their behaviour with consumers. They must treat customers fairly, essentially. And then in the Consumer Credit Act, there is something called the Unfair Credit Relationship Test, which is a very powerful tool for courts. And here courts can actually set an agreement aside, can change the terms, can change the payment that is due, and basically has very extensive rights in relation to the agreement as a whole. Although, of course, the agreement has to come before the court in the first place for the borrower to be able to receive any relief through these means. There's also an addressing of exploitation. There's specific interest rate controls now in place, with a cost cap on the high-cost short-term credits, such as payday loans. There is a default fees cap and the total cost cap of 100% on any amount borrowed. Creditors that break the rules face sanctions, for example, fines, or even withdrawal of their authorization to offer products in the market. And there are private remedies then through the court through breach of the rules, although not the high-level principles. Only the FCA can bring sanctions if they are breached. But also there are remedies through the court by means of the section 148C, which is the unfair credit relationship test. Now, the underlying rationale for regulation gives huge importance in consumer autonomy, choice, and responsibility. And there is a promotion of consumer empowerment and self-reliance and self-help, and entrepreneurism of the self, if you like. And this is reflected in the statutory objectives by which the FCA conduct their supervision and their regulation. And there is actually tension there between the statutory objectives, which include an effective competitive market, but also consumer protection. But within that consumer protection statutory objective, there is a general principle that consumers should take responsibility for their decisions. Now, this may be, as we see, a bit of a problem, because although the idea behind this is that we have a competitive market, an effective competitive market, for many consumers, as was pointed out this morning, for many consumers, actually, a competitive market simply does not exist, and we'll come back to this. Now, there is some emphasis on unfairness in regulated policy, and the FCA is certainly progressively regulating with the vulnerable consumer in mind. There is key policy strategy for protection of the vulnerable consumer, and this includes things like financial inclusion and access to affordable credit. Further initiatives are being introduced. There's to be a breathing space where consumers find that they cannot pay their debts. There is an establishment of a single financial guidance body that provides free debt advice, and there will be further regulation on products coming into the market, like the buy now, pay later products. There are, however, issues with this approach. There are problems with the information paradigm. Do people actually read the information? And if they have the information, do they understand it? Is there too much? Is there too little? The financial inclusion initiatives in affordable credit still include an element of risk when it comes to assessing consumers to take on that credit, and therefore do not necessarily provide access to all. And it is also the approach of vulnerability and the vulnerable consumer that has created a bit of a problem. Now, I say that with the caveat that the FCA have moved significantly on this since I started looking at it. But vulnerability has traditionally been seen in terms of populations and becoming vulnerable if certain circumstances are present. However, just because you are in a specific group does not mean you are vulnerable. And by the same token, just because you are not in a defined group does not mean you are not vulnerable. A lot of knots there. So how should we approach consumer protection in this context? The consumer credit relationship may be one of the most important or impactful commercial relationships that we encounter as individuals. So it is an incredibly important issue. I found Martha Fineman's theory of vulnerability to be extremely helpful here, certainly from a theoretical perspective in trying to understand what is going on. Fineman's work examines and presents the concept of vulnerability as constant, something we all experience, being an inevitable consequence of our embodiment and bodily fragility. And I think COVID has probably demonstrated that more than any other recent events. Vulnerability is a universal, ever-present experience. We're not more or less vulnerable. The theory considers a sectored approach, therefore, to the individual as two-dimensional and inadequate. So Fineman's vulnerability analysis argues that we are all as individuals vulnerable. And so in fact, what is often described as vulnerability is in fact a susceptibility to the negative effects, and in the consumer credit market, the negative effects of credit, such as problem debt. These effects, though, are not the creators of vulnerability, but I think what they do, rather reflecting Martha's theory, is that they reveal an underlying condition that is in fact always there. Furthermore, Martha says that vulnerability is not a comparative concept fixed by particular circumstances or particular life stages, and that in fact there are inevitable differences between individuals arising from our embodiment and how or the extent to which we are differently embedded in social relationships and within institutions. Vulnerability, whilst universal, is also particular, something that is experienced through our relationships with each other, social institutions such as the family, the market, the state, and the resources distributed through them. Indeed, these relationships and institutions exist as acknowledgement of human vulnerability, if you like, and dependence. Relationships are key. And I think this has a real resonance with the consumer credit relationship, which, as I have said, I think is key in our basic everyday lives. But it's not just, in fact, when you look at the consumer credit relationship, there's actually a web of relationships around the provision of credit. We may have a motivational influence from other relationships. There was a study in Brazil that looked at what they termed gifted relationships, where in fact individuals borrow to guarantee their relationships with others. They may take on long-term debt, even problem debt essentially, but they feel it is worth it for the emotional return that they get. The give, receive, reciprocate. And I can see how that might translate into any culture, in fact, say, for example, in the UK, where parents will borrow to allow their children to go to university, to pay for their accommodation, to pay for their maintenance. Gifts at Christmas, in order to cement a relationship with another member of the family or with some other relative. You can see how this actually can translate across many different cultures. Debt might be even used, or borrowing might be even used to escape a relationship if it's a bad relationship, allowing that person to remove themselves from that relationship that is detrimental to them. So looking in more detail, however, at the consumer credit relationship itself, and we ask, who is the borrower? Is it really that liberal, autonomous subject, that average consumer? Well, that concept sidesteps the context of debt. A borrower may not have any real choice in terms of whether or not they borrow in the first place or at what price they borrow. Their choice is only there if lower priced products are available to them. They can access their lower priced products. And there are also other factors that influence borrowing decisions. There are those factors of human decision-making and of just being human, internal factors such as human biases, bounded rationality, overconfidence and emotional responses. We do have those externalities such as illness, the loss of the job, or other issues that happen to us that mean we need to borrow. And then there are those general motivations of investment, comfort, or materialism. Now that relationship is inherently imbalanced. Both borrower vulnerability and creditor vulnerability can be exposed by that relationship. The borrower vulnerability in the ways I've just described, but creditor vulnerability as well. Creditors are, after all, institutions that are run by humans. I can see, Chloe, have I not got much time left? Okay, I'll be quick. So moving on then, what is the answer to that? Well, an answer is in resilience, and vulnerability theory calls for a greater response and responsibility from the state. This here has to be beyond institutions such as the law, regulatory and enforcement agencies. These institutions are themselves vulnerable. Support for all consumers through institutions of resistance, education, financial citizenship, and extensive free financial advice at all stages of the process will help provide that balance and that integrated support. Further support is needed to the alternative institutions such as credit unions and community institutions that provide low-cost credit. They have a part to play, but they need further support. All of this is an access to justice issue. Weaker parties should have access to the market and affordable credit. Consumers should be put in a position to access and enforce their rights of participation. This is about a social justice and equality. And as credit can be the gateway to everyday living, we have to see it as an essential service. So just to finish off then, I just want to say here that I believe there is a universality to vulnerability using Martha's theory. We need a balanced combined approach to the protection of the credit consumer, which needs to be regulation and support and consumer resilience, provided not just by regulation, however, but also by institutional support through funding of debt advice and through funding of financial education and other methods of support that can help the consumers deal with borrowing and deal with debt as it arises. There are some other things I want to say, but we can always maybe bring those out in the question and answer. And thank you very much. Sorry, I had to rush to the end.
Perfect. Thank you so much for that, Sarah. That was really interesting. And again, sort of thinking about the connections emerging between the papers, this kind of interplay between individual and state or kind of entity based vulnerability. So thank you. And now we're moving on to our final speaker, Roya Rifath, who is a doctoral researcher at the University of Exeter, who I believe also has slides and is going to be speaking to us about vulnerability, asylum and sexual orientation. So over to you, and I will turn off my camera.
Thank you, Chloe. I'm just going to share my slides now. Can you see those, Chloe?
Yep, perfect.
Brilliant, thank you. So good morning, everyone. First, thank you to Tim and Christine for inviting me to present here. It's been really fantastic listening to all the brilliant speakers so far talk about vulnerability from so many different perspectives. So today, as I'm currently in the last year of my PhD at the University of Exeter, I'll be presenting part of one of my chapters about vulnerability, asylum, and sexual orientation. So my presentation today will follow this structure. I'll begin with some background and a brief overview of my PhD research. I'll then move to talk about vulnerability in refugee law and domestic policy, and then how we can frame vulnerability so that it can be more effective with the use of some trauma-informed care approaches as well. So my research is focused on the UK's asylum process. The reason I'm conducting this research is due to the high number of refusals for people who base their claims on their sexual orientation, but then a majority of these are then granted on appeal. It has also been reported that there is a much higher standard of proof being used in practice. It's meant to be a reasonable degree of likelihood, but some of my participants have described it as being essentially the civil standard and sometimes close to criminal. The combination of this higher standard of proof, as well as the refusals, result in really lengthy appeals processes, and this extends the entire asylum process for individuals, resulting in adverse effects on the well-being of applicants and their mental health too, especially during the waiting times for decisions and in between those appeals. To conduct this research, I use a transdisciplinary approach of law and psychology, which includes some qualitative studies as well, which I'm currently conducting. So moving now to vulnerability in refugee law, I'll first begin with the international arena. To begin with, the term vulnerability isn't mentioned at all in the Refugee Convention, which is the main international instrument regulating refugee laws. But the concept of using vulnerability to address the specific needs of certain groups of the population has been emerging in the protection of refugees and migrants over the last couple of years. The New York Declaration 2016 acknowledges that refugees and migrants have similar vulnerabilities, that women and children have particular vulnerabilities that need to be addressed due to potential exposure to discrimination, sexual, physical, and psychological abuse, and human trafficking. The UN Global Compact for Safe, Orderly, and Regular Migration reaffirms the New York Declaration's protections for those who are deemed vulnerable, with an entire objective out of 23 objectives to address and reduce vulnerabilities in migration. The Global Compact doesn't define vulnerability, though, or situations of vulnerability per se, but does provide that policies need to be developed to give necessary support to migrants with a focus on particular cases. The emerging focus on vulnerability in the international refugee realm to prioritize or provide special safeguards at the international level is really interesting, especially considering the Refugee Convention doesn't make any mention of vulnerability. But there still seems to be no specific definition of vulnerability, but rather just certain situations that people may be in that require some safeguards based on their identities. Moving to the regional level, the lack of a specific definition of vulnerability is also echoed in other areas of refugee law. For example, at the European regional level, in the 2011 case of MSS and Belgium and Greece, which Dimitrios talked about earlier, the European Court of Human Rights found an asylum seeker was particularly vulnerable because of everything he had been through during his migration and the traumatic experiences he was likely to have endured previously. In this case, the court made the link between the trauma faced by the individual and the vulnerability of the asylum-seeking process and the individual themselves. So the court assumed vulnerability in that situation. The court then went on to state vulnerability was inherent in his situation as an asylum seeker. So the court here changed and altered the label of vulnerability to all persons in a situation of solely being an asylum seeker. Or authorities tend to categorize certain populations as being vulnerable simply due to their belonging to a certain group. So in a 2016 case relating to detention, OM in Hungary, the court found by virtue of being a sexual minority in Iran, the applicant was a member of a vulnerable group, and authorities didn't take this into consideration when detaining the applicant, among other detained persons from countries with widespread cultural and religious prejudice. Refugee policies similarly categorize certain persons as being vulnerable simply due to their belonging to a certain group. For example, in the 2003 EU Reception Conditions Directive classifies vulnerable persons with a few examples, which includes minors, elderly people, pregnant women, etc. So moving now to domestic policy, which is where my research is focused. Looking further into that domestic level, the UK's Vulnerable Persons Resettlement Scheme this was from 2014, was in response to the Syrian conflict and in partnership with the UNHCR to help those in the greatest need. That's what it was phrased as. It was the responsibility of the UNHCR to determine those who are vulnerable using their vulnerability criteria. So for this particular scheme, there were 7 vulnerability criteria used by the UNHCR. This was legal and or physical protection needs, survivors of torture and or violence, medical needs, women and girls at risk, family reunification, children and adolescents at risk, and lack of foreseeable alternative durable solutions. People of a minority sexual orientation weren't included in this criteria, but the UK Home Office confirmed in 2016 that those at risk due to their sexual orientation fall into the legal and physical protection needs category for the purposes of resettlement. In the UK, vulnerability is also used in the detention context. The UK Home Office guidance for adults at risk in immigration detention uses the term vulnerability in reference to those who are particularly vulnerable to harm when placed in detention settings. It doesn't include a specific definition of vulnerability, but it does give an exhaustive list of indicators to identify those who may be vulnerable to harm specifically. So these are including serious physical disabilities, serious physical health conditions or illnesses, mental health conditions, torture victims. But for torture victims, this also includes a 2-stage test to assess whether they are actually indeed victims of torture, transsexual people and intersex people, and other conditions. Persons who may be vulnerable to harm due to their sexual orientation aren't specifically featured in this guidance, despite reports of homophobic harassment, physical abuse, and sexual assault faced whilst in detention. Even though the UK Home Office's adults at risk guidance list is non-exhaustive in relation to people who are vulnerable to harm, sexual minorities should perhaps be specifically mentioned given the trauma often faced by this group. The guidance is an example of how using vulnerability to prioritize people who are more likely to face harm out of the rest of the population can sometimes ignore other groups who may require special provisions or safeguards too. Further, the inclusion of a 2-stage test being used to assess authenticity of victims of torture brings an additional complexity to determining vulnerability to harm as well. The 2016 API claims made by people based on their sexual orientation will often highlight a fear of being vulnerable, singled out, or suffering harm, it says. It then goes on to giving examples of situations where one may have experienced physical or psychological harm. So what's missing from the 2016 API is what exactly vulnerability means and the effects of these vulnerabilities to this group, and what the effects this might have on their actual asylum claims as well. The only information given are examples of the impact felt by some claimants from harm. So they may have faced depression, anxiety, isolation, post-traumatic stress, suicidal tendencies and attempts self-denial, hatred, shame and guilt, and stress-related psychosomatic symptoms and diseases. But the 2016 API doesn't actually give any guidance for how to identify nor address all of the harms faced that they've listed in the policy document. The UK Home Office guidance on asylum interviews, so this was from 2021, addresses vulnerabilities too, in that there are vulnerabilities identified that special measures could be taken into consideration. For example, rearranging the interview if there are any vulnerabilities that come to light, or for safeguarding purposes, if there's evidence of the claimant having particular vulnerabilities. Within this document, there's no definition of vulnerability again, and there are only a few indicators of what vulnerabilities are to be considered. In preparing for the interview, caseworkers are directed to consider evidence or indication of vulnerability or trauma, such as being a survivor of torture, as this may affect abilities to remember peripheral detail. What we do see in this policy is vulnerability being vaguely linked to trauma. So trauma is mentioned several times throughout the 2021 guidance documents, with measures in place to accept the effects of trauma having on a claimant's ability to engage with the process, namely their ability to recall memories that are relevant to their asylum claims. So the myriad of ways vulnerability is referred to just in the domestic UK context exemplifies the lack of definition and specific aspects of the term that allows for favourable treatment, prioritisation and special safeguards to very few people who are actually claiming asylum. So we see vulnerability being used in refugee law and the importance of it, as it does give these special safeguards and favourable treatments, often, but then it's based around these fixed categories of people in fixed circumstances alongside very fixed labels without giving any specific definition of what vulnerability means. What is missing from current guidance or policy in the UK seems to be the question of vulnerable to what? And looking to different approaches of defining vulnerability, there are so many different approaches currently. But one of the main ones, for example, is Professor Martha Feynman's vulnerability theory, which proposes vulnerability as universal, constant, and inherent as it arises from our embodiment. Feynman contends vulnerability manifests itself in different ways and at different times, depending on our differences in the ways we interact and react in relationships with others and within institutions. Feynman believes resilience is what protects us from harm, setback, and misfortune, and actually names 5 sources of resilience that institutions can provide. So these are physical, quality of life, human capital gained through education, training, knowledge, and experience, social, sense of community belonging, ecological and environmental, physical environments, and existential, meaning beliefs and culture to understand our place in the world. So the idea of resilience is echoed in other approaches as well, in psychology, for example, and especially in relation to well-being too, which is one of the main issues that I'm focused on in my research in terms of asylum seekers basing their claims on their sexual orientation. So Guidry, Grimes, and Victor include 6 foundational dimensions of well-being, which have some similarity to Feynman's sources of resilience. So these are health, physical and mental functioning with minimal pain and loss of control over one's body, personal security, absence of assault and the threats, reasoning, ability to gain knowledge about the physical and social world for practical decision-making, respect, recognition of each person's intrinsic moral worth and dignity, attachment, this meaning a feeling of belonging, like we have a place in the world, emotionally deep bonding with others, and self-determination, ability to make and pursue options for ourselves. So applying all of these different varied approaches to vulnerability to my own research findings, which I don't think I'll have enough time to get into, I found that vulnerability fluctuates depending on situations, depending on the individual, depending on what stage of the asylum process they're at. But during the asylum process itself, they face specific barriers and challenges that are not really accounted for in current policy. For example, collating evidence for claims is often done within the UK as they conceal their identity in their countries of origin. Yet there's very little allowance for example, people who don't want to go out to gay bars or clubs, which is what has been seen as acceptable and good evidence, and sometimes promoted evidence to use as well. Also, for example, people in detention attempting to gather evidence or speak with their solicitors, they often don't really feel comfortable talking about their sexual identity and their case because they might be detained with people who might have adverse views about sexual orientation, people from their own countries of origin, for example, and indeed the detention custody officers there as well. So in terms of attempting to frame vulnerability, first, there were a few issues with the label of vulnerability that needed to be addressed, and I think this was touched upon by quite a few presentations earlier today. For example, the stigmatizing effect that the label often comes along with, especially considering the amount of resilience it takes to actually flee a country of origin and travel to apply for asylum, to even engage with the process itself really shows the masses of resilience that they have, and it can sometimes be undermined with a label of vulnerability. And people sometimes may not see how the label itself might actually give them a really favorable position due to the term being used, due to just the term vulnerable being used. So keeping this in mind, it was clear that there are specific barriers being faced by people basing their claims on their sexual orientation that needed to be addressed. For example, concealing their identity even after arriving in the UK can have an adverse effect on their claim. Yet this is an understanding considering their experiences and their backgrounds. Therefore, perhaps using a trauma-informed method to addressing gaps and issues in policy could provide some sort of protection, still taking into account the vulnerability, but finally approaching the actual effects that vulnerability has on someone's ability to engage with the process. So using a trauma-informed approach can already be seen in some guidance. For example, the guidance I mentioned earlier, the Asylum Interviews Guidance, one of the most recent documents produced by the UK Home Office, refers to difficulties in recalling memories when someone has experienced trauma. Though it's not very detailed and developed, we can see glimpses that we can actually build upon using trauma-informed approaches. And then recently in the LGBTQI+ Afghan Refugees House of Commons debate, this was on the 21st of September, Victoria Atkins, in referring to resettling Afghan refugees who are of a sexual minority, said that they're going to use and they're intending to use this trauma-informed approach in conversations with people. So we see another glimpse of it coming to light now. So as part of my PhD thesis, I intend to set out a so-called vulnerability framework that uses trauma-informed approaches. So following the methodology that I've described, it'll allow for fair engagement with the process for those basing their claims on their sexual orientation, thereby creating a more efficient process, as there can be more of an understanding of the specific trauma and the specific vulnerability criteria that we mentioned, provided in guidance that can hopefully reduce the waiting times, which is, from my findings, one of the most difficult stages of the process for individuals, and it seriously affects their well-being. Thank you all for listening. I hope I've stayed in time. I've put my email there if you had any questions that we don't get to answering today. Thank you.
Perfectly on time. Thanks so much for that final presentation, which was great, really fascinating. And I think we'll have many really ripe conversations in the 15 minutes so we have to have those conversations. So right now the floor is open. You can either, if you'd like to ask a question or make a comment, raise your hand via the reactions button that should be at the bottom of your screen, your Zoom screen, or you can type the question or comment into the chat and I can read it out on your behalf. Someone just, Andrew Beetham, just apologising for having to leave and saying thank you for the talks. So yes, anybody who'd like to start off is very welcome to do so, including the members of the panel.
Could I actually just make a comment? It was when Roya was giving her talk, and I was really struck by, there was one thing, there's real connection there with what you were saying. I think it was when you were talking, was it the API instructions or the guidance? And you were talking about it was connected to harm. Now, the FCA has a definition of vulnerability. I mean, they've got a hard job on the FCA, actually, because they are very much constrained by their objectives. But so they try to provide this definition of vulnerability. And they say that a vulnerable consumer is someone who, due to their personal circumstances, is especially susceptible to harms, particularly when a firm is not acting with appropriate levels of care. And I thought that was very interesting because that looks like guidance from the government perspective, regulatory perspective. They're using this idea of harms, but then what are those harms? So then the FCA has to say to creditors, right, well, we've got these various boxes that show particular characteristics that might reflect vulnerability. So then what they're doing is essentially the creditors are going to naturally float back towards those boxes, even though the FCA are doing their best to make it a more sort of holistic, thing that can, happen to anybody at any particular time. While you keep it in potentials and you keep it within the idea of harms, you're always going to be boxing, to a certain extent, even if it's more nuanced. And I just thought that was quite an interesting connection. It's just something that occurred to me while you were speaking.
Yeah, it was really fascinating to listen to the previous discussions around a definition of vulnerability, because I I've been working on answering that question for a while, just within the asylum process, but it just seemed like vulnerability wasn't the right term to be using, because it is very boxy, like you say, and if people's identities don't fall in a box at a certain time, then they're not really given a favorable position, and sometimes ignored. So it was really interesting, considering the previous discussions we've had already in the conference. Thank you for your comment.
Thank you very much, Sarah, and for your reply as well, Roya. I think it's something I was thinking myself about, kind of the ossifying potential of defining certain kind of ideas and concepts. I see there's at least two hands raised in the amongst the participants. So I'll invite Christine next to ask her question. Yeah.
Thank you. So thank you once again to everybody. Fascinating. I've got a question to Steve, Professor Headley, just to perhaps expand a little bit more on what's your understanding of vulnerability, because you approached this fascinating question of tort law and the role it's got to play. But I wanted to know a little bit more about your view of vulnerability and how you conceptualized it. And then to all the speakers, I would be very interested to hear, which is what I'm going to do in all sessions now, since I've got to do the closing of the conference, and I'm really interested in that point. What do you see to be the main roadblocks, the problem that stops the vulnerability problem being solved? Is it political? Is it economics? Is it a sociological problem? Is it all of those things? Is it just one thing that you can single out? So I'd be very interested to see your views on how we can push past without a definition. So I'm leaving the issue of finding a common definition. So within your own spheres, what do you see the main roadblock? Thank you.
Yes. Well, I'll start, since you've asked me specifically. Tort lawyers tend to see rights issue in terms of the interests of the people claiming. You've got an interest in bodily integrity, you've got an interest in your property not being destroyed or damaged by other people. Now, there are all sorts of nuances about how seriously you take that. Some people take a very narrow approach and talk in terms of rights there, meaning it's not enough just to identify what interest you protected, you will also got to identify who it's protected against. They're trying to be more precise that way. I was taking the broader conception there, that in most personal injury actions, you're protecting people's bodily integrity, their rights not to be injured further than they have been already. But if you broaden it out that way, of course, tort is not the only institution that protects those particular interests. An awful lot of social security law or pension law could be seen as protecting your interests in being able to go on enjoying life, go on earning money, which depends crucially on the state your body is in. So I would define vulnerability in terms of protecting certain interests, and the ones that come up most frequently in tort cases would be your bodily integrity and your property remaining in the state that it was in. Of course, tort is broader than that. You get into arguments about the extent to which your reputation can be seen as something that is protected, and you get into the area of defamation law. There, I was kind of avoiding that, because while you can talk about that in terms of interest, it brings up a whole host of other issues. That's your first question. Your second question was addressed to everybody, including me. I see essentially the problems here as political. The biggest problem is that the issue is too big. Tort scholars in the past have talked about reforming the law of tort. The trouble is, tort covers so many things. There was a royal commission set up in the late 70s, the Pearson Commission, which all lawyers know about, which was to a certain extent looking at reform of the law of tort. But there were just so many issues there. They were expected to come up with some grand pronouncement as to which areas of tort were worth keeping and which should be changed. But they never managed that. They could certainly never get agreement amongst the various members of the committee. They ended up with all sorts of highly specific proposals, most of which counted as improvements, but they couldn't really be thought to be tackling the question generally. I would say that Tort has become such a large institution these days that you've got to decide in what sort of chunks you want to deal with it. It's the old problem of eating an elephant. One bite at a time is the usual recipe. You want to decide what the bites will be. To a certain extent, the politics is becoming more realistic here. For example, nobody talks about reforming tort. They talk rather of reforming the law of medical negligence or reforming property insurance or something of that sort. That may be reducing the political problem to a size that it can actually be dealt with, but there's been precious little progress yet. That would be my answer.
Yeah, I'll talk from the property perspective, and then I'll kind of globalize it a little bit more. I think the problem is a bit harder to pinpoint, but maybe it comes down to norms and narratives about what we collectively think about property doing. In Squatters in the State, we spend a lot of time talking about the pre-political expectations that or the pre-political narratives that imbue owners with some expectation of being immune from some greater sense of responsibility in the context of their property relationships. And in so many ways, those pre-political expectations are bolstered not just by the existing law, but by narratives and by political undercurrents. And so, it's almost this much larger scaffolded problem where there are these various aspects of the norms that have been built onto each other that make it really hard to penetrate that question of vulnerability or recognizing why other people's vulnerabilities should shape the way you think your property institution your property should respond to that state.
Would Sarah or Roya like to comment on the second of Christine's questions?
Yeah. I'll let Sarah go.
Sorry, I muted myself, which isn't a bad thing, really. Can I remember? So it was what are the roadblocks? I think that's what you said, wasn't it, Christine? I think, well, just from a consumer protection point of view and consumer credit, bearing in mind, I take the view that in fact all consumers are inherently vulnerable in the credit sphere. The main roadblock probably is actually the statutory objectives of the FCA, where they have the operational objectives of ensuring an effective competitive market as against their consumer protection objective, which they have to balance those two things. And you see that coming through the various consultation papers and policy papers. And then the overall general objective having to make sure that markets work well. So while you've still got that emphasis there rather than on consumer protection, that's always going to be, a thorn in the side of any regulator that wants to emphasize or make consumer protection the top thing, because they're always trying to having to make that balance because they're required to do so. So, I mean, that would be my take on that. And there is a question in the chat actually, which I sort of half answering that at the same time, because Chris is asking about the FCA's consumer duty, and they're suggesting there should be a new consumer duty as a new principle. Well, actually, although actually it's still really immersed in consumer responsibility when you read through the consultation, it is moving towards what the idea that actually, yes, all consumers are essentially vulnerable, and therefore we should be moving the goalpost up, right? So everybody should be treated as though they may be vulnerable at any given moment, and not if they have a particular characteristic or anything else. The consumer duty is the creditor should be behaving well in relation to all consumers all of the time, because at any given moment, something may happen that will expose the vulnerability that is inherent within them. So I think that's I sort of straddled two things there, but I just sort of popped that in while it seemed sort of, relevant. So thanks.
Absolutely, Roya. How about if I read the question out from Chris? Because it might be that actually you want to respond to the two together, if you want to respond to it.
Yeah,
So the question,
absolutely.
is that okay with you? Yeah, fantastic. So the question that Chris Fitch has written into the chat is, why do the panel think that many sectors who use the term vulnerability to frame their strategic approach are then so keen to move on from the term? In financial services, vulnerability has provided a flagpole to organise around, but the FCA's move to consumer duty seems to herald a desire to move away. Is this an over concern with semantics by academics? Never. Or a natural phase in the evolution of consumer protection? So that was addressed to everybody on the panel. So perhaps, Roya, if you'd like to come in first, then I can see if others want to come in. And then there's a question also from Mark, and then there's another question from Chris in the chat. Okay.
Yeah, brilliant. So I'll start off with following up from all the discussion we've had in response to Christine's question about the roadblocks that we've had in trying to solve this issue of vulnerability. And I think from the refugee perspective, we've given certain groups this special label of being vulnerable, and therefore they have special safeguards in place in refugee law. And the problem that I think we're having now is we're realizing that those labels just don't really work, because we're ignoring some parts of the population which really shouldn't be ignored, and they should have some sort of favourable position as well, or just some additional help or safeguards in place. And because we've based vulnerability on people's identities rather than why they're actually vulnerable, I think that causes a massive issue. So I think with now moving on to answering Chris's question as well, of in the refugee realm, it seems to be an emerging thing. Vulnerability is emerging in our policy. So we see it popping its head more and more in all sorts of policy. And it was only in 2021 that the UK Home Office policy itself started referring to vulnerability more and more, but they're now referring to it in this trauma approach. So people might be vulnerable to harm, like we mentioned earlier, but also if we look at those trauma indicators, for example, someone suffering from PTSD or someone who's been through a different form of trauma, what effect does that have on their ability to actually engage in the process? So with that, I think it's not so much that we're using a wrong approach or anything like that, but I think it's more that we have these fixed categories and we can't take that category away from a group of people. And if we keep adding lots and lots of people, we'll just have the entire population needing special safeguards, when that might not be the case during certain stages of the asylum process. So in that, I think that the narrative has changed a little bit to include this idea of harm and trauma rather than just this staunch label of vulnerability for a specific person. But that would be my take on it from the refugee side. But I'll pass the floor on to the other speakers in the panel.
I'm going to be a very rude chair and just say I might tack on. I realise we have Mark's hand up. Chris's second question, because I think it builds slightly on your answer there, Roya, in the sense that his second question is directed to Sarah, but in a way I think it touches on the more general theme of if vulnerability is this kind of universal thing, but also something that's ascribed to specific individuals and groups, how does that work? So his question to Sarah, but the others might want to reflect on it, is if all consumers are vulnerable, then how can firms meet the FCAA objective of ensuring the outcomes of vulnerable consumers are as good as those of other inverted commas consumers? Have the FCA set up firms to fail? So if I could invite the panel to reflect on the more general question by Chris and the sort of riff on it that I've just glossed, then we'll come to Mark's question, and we'll probably at that point have to wrap things up.
Sorry, Chloe, what do you want me to answer Chris first?
You could
Yes.
be.
Oh, sorry. Yes.
Sorry, I didn't explain
Okay.
that well. If you want to answer that, but the others who haven't yet spoken about the general question of Chris's might want to do that after and maybe think about the point he's raising about universality and particularism as well.
Okay. All right, Chris. Thanks for your second question, Chris. So what I was saying was that I think all consumers are inherently vulnerable. Okay, so when you look at the definition that the FCA have of a vulnerable consumer, they say the consumer is someone who, due to their personal circumstances, is especially susceptible to harm. And what I'm saying is I believe that all consumers are susceptible to harm where a firm is not acting in the, with the appropriate levels of care. So when you say, how can firms then meet the FCA objective ensuring the outcomes of vulnerable consumers are as good as those of other consumers? I presume you're talking about that's a self-set objective that they've got in terms of when they're talking about their business plan, and the fact that they now have, obviously, this the aim is that vulnerable consumers should be looked after and should be treated properly by creditors. I'm not sure if they set up firms to fail. What they're doing there is setting out a set of standards that they believe should apply to a certain group of consumers. Now, they say that potentially that could be anybody. They say that they do, potentially it could be anybody, but then they tend to, we've got then these four sort of like different types of characteristics that are demonstrated for the firms. Now, I'm not sure they're setting them up to fail, because if the firms are responding to what the FCA have put in their consultation, in their guidance and in their rules, then they won't fail in terms of making sure that they are complying with what the FCA require them to do. I think what I'm saying really is that actually we should be able to, the FCA should be able to move beyond that. And instead of, looking at it from a more holistic perspective, and the consumer duty is starting to move them in that direction. I'm not quite sure if I completely answered your question there, but it's best I can do with a written question, I think, without sort of discussing it here. Oh, thank you. Thanks, Chris. I mean, another time, obviously, get in touch and we can talk more.
So I'll make one quick point on why I think institutions move away from vulnerability and towards other things. I think vulnerability itself is inherently vulnerable to discourse type attacks. So for example, like Gowan's discussion of sin talk, sick talk, or system talk. Whereas when we start putting things into context of resiliency gaps, or we try to, that's something far more pragmatic, something far more practical that is capable of creating solutions. And in particular, in thinking about Gowan's idea of systems talk, systems talks is ultimately challenging the nature of the state or the nature of law itself to address a particular problem. Whereas when we talk about sin talk or sick talk, we're really focusing on the individual and talking about why that individual fails to have resiliency in certain spaces. And so I think, again, the language of vulnerability, whereas it's a super important step to get to resiliency in and of itself, I can see how institutions and how states may say, may very quickly bypass to resiliency, because resiliency is a bit more pragmatic, it's a little bit more practical, and there are some at least identifiable ends that you can target for how resiliency is filling gaps.
Mark, did you have a question you also wanted to ask? Because I see your hand is raised.
Yeah, so I just wanted to ask a question to Steve. And I thought I loved your talk, loved the discussion. I teach tort law. I moonlight in tort law on the side. But one of the articles that I usually give students to read is Jules Coleman's Doing Away with Tort Law. And Jules talks about how we could do away with tort law by just simply deferring to contract law or criminal law as a way of solving all of these problems. But I think his main point is that tort law fills this normative gap of how we import social expectations into relational interactions. And so I'm kind of curious. I wanted to press a little bit on whether recognizing the inherent lack of usefulness of tort law actually loses some version of social normative construction through the law.
Yes. I mean, this is a line that a number of people have been taking. If you look at Ernest Weinrib's work, for example, in Tort, very much saying, well, tort law lays down the basic rules of social interaction between us. It means we must all behave reasonably and so forth. And that's all very well and good. It would be all very well and good if it were true. The trouble is, if you actually go out and start looking for evidence that people are guided by tort law, you'll find they're not. Even when tort law does say something useful. For example, tort law has all sorts of injunctions about how you're not allowed to hit people and so forth. Now, there is a strong social norm not to hit people, but people aren't bothered about tort. And in fact, it's very rare that there would be an action for tort in those circumstances. They're worried because the police would turn up and charge them with assault. Equally, if you're talking about car driving and the like, car drivers don't have the least idea what tort law prescribes for them in that situation. They have an awful lot of rules in their head. They'd never have got through the driving test if they hadn't had all those rules in their head and be prepared to obey them fairly automatically. But they're not tort rules. They're statutory rules about what you're supposed to do in certain situations, what you're supposed to look out for. And in fact, the tort law in that situation is no guide at all. It says simply, well, you're supposed to act reasonably and with regard to the people around you. Well, great, but what does that mean? When you come down to the specifics, the rules are actually supplied by other areas of law. So in relation to those social interactions, I don't say that what tort prescribes isn't quite reasonable, but when you look at what actually happens on the ground, tort law has nothing to do with it. People don't go around hitting each other because there is the criminal law. They stick to contracts because there is a law of contract. When you look for actual evidence that tort law has some kind of an effect on the way people behave, it's not there. That's why I direct people towards the material on what is the social effect of tort. I think there's an assumption that is made in very simple moral descriptions of tort, and for that matter in Economic 101 descriptions of tort, that look to the position of the rational actor and say, what do they do in that particular situation? You act in a careful manner because it would be the moral thing to do, or because it's a good use of resources and so forth. It all looks at it on a day-to-day basis. But again, think of your own life in that situation. You aren't careful because you've weighed up the economic costs of the matter and are considering what to do there. In fact, the whole point of getting the liability insurance in the first place is so that you're not at that sort of risk, that you don't have to consider issues of that sort. So it's not that the rules of tort aren't good moral rules. But if you ask, do people know what these rules are and do they follow them because the law of tort says so? The answer is, for the most part, no. It's other areas of law. It is your criminal law. It is your contract law that is actually having an effect on the ground. Tort law, not so much.
Thanks so much for the questions and your responses, everyone. I think we are now out of time, so I'll have to draw things to a close. And so, yes, Christine's written into the chat. There's a break now, and then at 5:30, there's new links for the last session as available on the program. So thank you everyone for your attention. I'm going to do one of these electronic clapping things, and take best care and enjoy the rest of the conference. Thanks very much.